Hello, my name is Jessie Jacobs. I will be discussing Title VII of the Civil Rights Act of 1964, but more importantly, sexual harassment in the workplace. So to give a brief background of Title VII of the Civil Rights Act. So the Civil Rights Act was signed into law by President Lyndon Johnson in 1964. Of this law, Title VII is specific to employers and their hiring and firing practices of employees. So per this law, it is illegal for an employer to hire or fire or really discriminate against an employee or prospective employee based on their race, color, religion, sex, or national origin. Title VII also created the Equal Employment Opportunity Commission, which that commission enforces the different provisions of the law that come about. Title VII also explains and outlaws 4 different types of illegal discrimination. Those 4 types are desperate treatment, desperate impact, pattern or practice, and retaliation. So desperate treatment is when individuals in similar situations are treated differently based on one of the protected classes. Pattern or practice is very similar to that. The only difference is instead of it affecting one individual, it impacts an entire class. Desperate impact occurs when a neutral employment practice is disproportionately excluding a protected group from employment opportunities. And then you have retaliation, which retaliation is when an employer is acting against an employee who has spoken up or taken legal action against that employer based on illegal discrimination. So the topic of the hour, though, with Title VII, it does cover sexual harassment in the workplace. Sexual harassment is defined by the EEOC as, unwelcome sexual advances in the workplace. But there are 2 different types of sexual harassment. So the first is the quid pro quo harassment, which is the harassment that everybody thinks of, right? So it's when the harasser offers favors or something of value, an advancement in your career or a raise or a bonus in exchange for sexual favors, right? So that's the sexual harassment everybody thinks of. But the one that's a little bit more subtle that nobody really thinks of and probably occurs more often than not is the hostile work environment. So a hostile work environment is defined as a culture or climate that makes someone of another gender uncomfortable. So the example of that would be John and Jim maybe having the conversation about, sexual relations that they had the night before, and Jill could be sitting at the table next to them in the break room and overhear it, and that creates a hostile work environment. If she's uncomfortable and she feels, any type of discomfort or any kind of off feelings about that is sexual harassment. Although they were not talking directly to her, she still is impacted. So that's the definition of the hostile work environment. In the manner of human resources with sexual harassment, human resources, the department or the manager plays a very substantial role when it comes to dealing with sexual harassment. In most legal cases, the ruling in those is based on how the Human Resources Department initially responds to the accusation of the harassment and how they go about an investigation. So the most important part is that the Human Resources Manager or Department treats each and every accusation of sexual harassment the same and treats them fairly. All complaints must be taken seriously and they need to be handled in the same manner, and there should be no wavering in the process. So if your first step is the harasser is suspended, that's got to be your first step in every process. That's my speech on sexual harassment in the workplace. Thank you.